Notice clauses are found in many construction contracts and are of great importance. These clauses provide notification from the parties to the contracts to each other in the event of certain circumstances to make them aware of any problems that may arise. Examples of such circumstances will be presented in this lecture. Notice clauses are essential because they give the employer an opportunity to look into the issue at hand and give them more time in order to determine the cause of the problem and whether or not the contractor is entitled to additional time or money as a result. The contractor's failure to follow the contract upon giving the notice results in him not being entitled to claim anything. So the notice clause must be accurate and unambiguous about what is required, as a simple error when giving the notice may cause problems later on for the party trying to rely on the notice. What the notice should look like. Whether it can be sent by post, fax or email with the address, fax number or email address. The information it must contain. To whom it must be sent. And a time limit to send it. Contractors must comply with all requirements of the notice clause. If they do not, they may not be able to make a claim for the circumstances that would have compensated them. A condition precedent is a condition that must be met before an entitlement can arise and often applies to notices of overtime or extra money. In many cases, the courts may well consider giving notice as a prerequisite for a valid claim. This will depend on the type of claim and the language of the notification clause. Sometimes sentences use the words prior case when describing the significance of the notice, but even if these specific words are not used, the clause can still have this effect. Contractors should be careful, however, even if the notice is not explicitly described as a prerequisite. Failure to give notice in these circumstances may invalidate the contractor's claim. The contractor may request a waiver from the employer if he fails to comply with the notice requirements. However, whether this will be agreed upon depends on the goodwill of the business owner. To remember: 1. That failure to provide the notice required under the contract may give the paying party the opportunity to challenge the notice. This may prevent a valid claim from succeeding. 2. Who should provide the notice? Notices must be given by a party authorized to do so by contract. 3. Notification via email. Notification of email need to be read. Proof of delivery will be sufficient. However, the contract may exclude email as a valid form of notice. Check the terms of the contract carefully, as some notices may be acceptable if given by email and others not within the same contract. 4. Notice by any effective means. Courts have considered this wording when used in contracts. They decided that this phrase could include email, postage, manual delivery and fax, as long as delivery could be demonstrated. 5. Agents for service of notice. The contract must contain the address of service of notices, and the procedure for notifying changes to this address. The contract should name the company official, for example company secretary, as opposed to the individual as the recipient. This will accommodate changes in personnel after the contract is signed. 6. Personal delivery means a delivery to an individual, which can be any person at the address for the service. This includes, for example, a receptionist rather than the person who is actually better to handle the notice. Make sure the contract names the person to whom the notice should be sent, for example a company secretary, to help avoid losing the notice. 7. Delivery by registered mail, or through a similar service. Remember to keep proof of delivery,